I'm going to ask you to close the top.
Yeah, that's probably a good idea.
Just flip. Thank you.
Where is it? Good morning, guys. Okay. Let me just send this to the groups. Out there. I'm live now.
And I got toothpaste for us to try.
Okay, thank you. Good morning, guys.
I'll join in a minute.
I want to start early today, so if you guys know anyone that wanted to be here for it, if you could send out the invites, that would be greatly appreciated. Greatly, greatly. Good morning. I'm just sending out the invites. I want to get started early, guys. We've waited long enough to hear this cross. Okay.
It's not time.
How many of you lost your minds yesterday because we didn't have this? I did. The way that yesterday went was a shit show. It was just everything it shouldn't be. So we need to make one decision. Do we want to hear the rest of the prosecution's questions for this witness? I know, but have you been watching it today, though? He is... Okay, you'll see what happens. We need to take a vote, though. You'd like to? Okay. Sounds good. So, if you guys know anyone that's usually here for our start time, if you guys could send them the invite, I would greatly appreciate it. I sent out as many as I could think of. I know everyone thinks, we're on the whole Michelle starts between 10 and 11, but I really want to start now. I can't wait. We have to get into this. We absolutely have to get into this. Oh, while we wait, though, there was a person of interest that was detained in the Connecticut mall mass shooting. It will be Colette. That's why we're here a little bit early today. I can't wait anymore. I was literally jumping out of my skin. I have to know what happens. I'm just nosy that way, I guess. So if you guys know anyone that wanted to be here for this, please invite them. I'm going to go ahead and get started.
Here in court and for the county of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is now open. You may be seated.
All right, good morning again, counsel. Good morning again, Ms. Reed. Morning, Dr. Welcher.
Good morning, Your Honor.
And good morning, jurors.
Good morning.
I have to ask you those same 3 questions. Was everyone able to follow my instructions and refrain from discussing this case with anyone since we left yesterday?
Yes.
Everyone said yes or nodded affirmatively. Were you also able to follow the instruction and refrain from doing any independent research or investigation?
Hi, Patricia. How are you?
Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read
Oh.
anything about this case?
We have new stickers. I made 2 new stickers. Hold on. The one that you've been asking for. That's why I didn't want to make it. Look at how the ceiling fan looks. And then we have one more I thought we could use for today. Defense. Literally defense. I've wanted to make it for a while.
Everyone said no or shook their heads. Thank you very much. All right, Mr. Brennan.
Thank you, Your Honor.
And if you guys want to use the stickers and you want to subscribe but don't know how, just ask us. We will help you.
Morning,
I
Dr.
love the
Welcher.
stickers.
Good morning.
When we left off yesterday, I was asking you about some of your opinions. I'm going to ask you those questions again, but before we do, I'm going to ask you 2 other questions. The first is, I'd ask you to turn to your PowerPoint, slide 110.
Let's take a vote, guys. I'm going to do a poll. Smiley face will be the one if you think that that Alessi is going to blow this out of the water. Sad face if you don't think Alessi's going to blow us out of the water. You got to click them.
I'm going to ask you a question about a series of your slides regarding this effort. This is 110.
The smile is Alessi's going to nail this. The cry face is he's not.
Could you also follow through to 111, 12, 13, 14, 15?
You want me to play the videos?
You don't need to play the videos. I just want to acquaint you for the question.
111,
12,
112, 113, 114.
You sure did, Iggy. We just
115.
clicked play.
how many times did you engage in testing where your arm and forearm touched the rear right of the exemplar Lexus?
3 times.
In any of those 3 times, did it ever leave any paint on the underside of your arm or forearm?
No.
You know, I've thought about this all night. He's doing it as if John had taken his sweater off and rolled up his sleeve. Thank you for subscribing, Kelly. Make sure you grab those stickers now because there's a lot of them. A lot. Thank you, Iggy.
If you could turn to slide 130, please.
Oh, yeah, it's really good.
What, could you go
I
back?
don't usually watch this network, but I noticed that they show Karen Reed's table, so I want to watch it to see if there's anything to point out to any of you guys. Good morning, Parker. How are you?
One, please. Perhaps it's 131, Dr. Welcher. There we go. Could you explain the significance of this slide, please?
Your Honor, this is.
Oh, could you take that down, Dr. Welcher?
Mr. Brennan.
We're going to move forward. Yesterday, when we left off, I had asked you.
So we need to take this.
Sorry.
You can take the PowerPoint down, please.
That was in a different spot on the slide. Hold on a second.
That's better.
Thank
Look
you.
what came.
Sorry, I had asked you yesterday about some of your opinions. I
Correct.
want to ask you about some of your opinions relative to that last effort that you made regarding testing between the Lexus.
This is
and your
Rihanna's
arm.
perfume.
Correct.
You had mentioned earlier on in your testimony that you reviewed a number of pieces of information and offered that you relied on some of those pieces for your opinion. Can you share with us, for this part of your analysis, what
love it.
pieces of evidence or information did you rely on for the opinions I'm going to ask you?
Love
Relative
you
to
too,
the
Kelly.
testing
Thank you.
on the arm contact on the taillight.
Yes.
So it was the physical evidence at the scene, the
Yes, sorry.
photographs of Miss Reed's vehicle, to a certain extent, my analysis of the Ring doorbell and the One Meadows
It smells so
event,
good.
the nature and
Excuse me, Your Honor, pardon my interruption. I just want to
Honestly, they're still getting started trying to get the slides up. We literally just started. Switch to that account so you can see court. Okay. You guys, this is the Rihanna perfume that everyone says that Rihanna smells so good. So I ordered it a while ago and it finally came today. And oh my God. I'm not a huge perfume girl. I will wear this though. Babe, this is the perfume that everyone says makes Rihanna smell so good. I'm so happy. I love it. I can't have strong perfumes. It's called Arabat Prestige Nyla. This is the one that she talked about doing in an interview. Yes, I am very happy it's here. I'm just going to leave that there. Yeah, it's not fact-based at all. Message me and I'll send you the link.
something or not.
Looks like he's counting on his fingers. Are you reading from something?
no, I am counting on my finger.
Thank you.
So
It doesn't compare to any of the others. This is amazing. Good morning.
doorbell,
Oh, guys, can I ask something of you guys? Yesterday got pretty crazy with the trolls. So if trolls come in and start spouting stuff off, please pretend that you don't see it. We're going to try to block trolls instead of interacting with them because there's some people that are wanting to learn and there's some people that just want to troll. So if you guys see people coming in saying she's guilty, this and that, just please ignore them. We'll block them. We don't need the time for that. Hello, how are you?
the type of shoes he's wearing, because I needed the same type of shoes. My exemplar
Thank
inspection,
you.
where I matched up the heights, the locations of the lacerations, and then the text stream data as well.
That information that you consider,
I'm excited
in
too.
addition to the text stream data you
Thank
consider,
you.
considering both those areas of information, do you have an opinion to a reasonable degree of engineering certainty in whether the damage
Hi,
to
Milo.
the
Come
defendant's
say hi to
Lexus
me.
is consistent with a collision with Mr. John O'Keefe on January 29th, 2022 at around 12:32 a.m.?
So there's been two potential theories that I've seen on that issue.
Renee, she was here. She just ran from us. Yeah, this is Brennan.
One is a glass was thrown at the rear of the vehicle and shattered it. The second one was
Completely
an
agree.
impact to the arm. If the impact is basically more than approximately 8 miles an hour, it will likely break the taillight lens.
Do you have an opinion whether, based on the data and based on the physical damage and your testing, whether that is consistent with a collision or a impact with Mr. John O'Keefe?
It is consistent with the collision as long as it's greater than approximately 8 miles an hour.
Do you have an opinion whether it's consistent with
Good
an
morning,
impact or
Liz.
collision with Mr. John O'Keefe on January 29, 2022 at around 12:32 a.m.?
With that caveat, yes.
I agree with you.
In your testing, did you consider, or do you have an opinion to a reasonable degree of engineering certainty,
Yes, this is behind us.
whether John O'Keefe's injuries on his arm
Listen, Jenna, you're in the wrong damn room if you think I'm not going to speak because you say so. This is an interactive type of channel. Go on to the next one.
and inevitably in the back of his head are consistent with being struck
Good
by
morning.
a Lexus identical
Direct.
to the defendant's Lexus on January 29, 2022.
Yes,
What's your opinion?
that it is. It is consistent with
Good
being struck by a
morning, Sam.
Lexus and ultimately contacting a hard surface such as frozen ground.
And does that specifically pertain to January 29th, 2022, around 12:30 a.m.?
Objection, Your Honor.
I'm going to allow that.
Yes, it does.
He did. My husband just caught that he was saying 8 miles an hour, not 24 miles an hour. Good catch, babe.
To finish, I'd like to ask you a few more questions.
It's the same as above.
You-
Michelle's Criminal Musings. We also have our Facebook group, guys, which is just Criminal Musings. But YouTube is Michelle's Criminal Musings.
You've written some papers on side swipe collisions or clipping. Can you describe for the jury and explain what a side swipe collision is or a clipping?
Flash
and
Gold
how
just
that
started.
may or may not differ from a direct hit on a pedestrian impact?
Sure. So what generally differentiates, say, side swipes or clipping contacts compared to, say, an inline impact or, say, a T-bone impact is what refers to that the object that you're hitting isn't accelerated up to the speed of the object that's coming in. So, for example, if I rear end a car, that car will be accelerated up as a result of the contact, and they reach what's called common velocity, and then they separate. And so in a glancing hit, you're going to have a glancing hit, and you don't have what's called complete momentum transfer, meaning the momentum from the car, because it's a glancing hit, doesn't completely transfer to the object being struck. For example,
Guys, if you guys could send your heart me, it's the one coin. We need one from 40 people. It will be greatly appreciated. We want to make 21 today.
you can drive down the road at 100 miles an hour and clip the mirror of a parked car, and you'll break the mirror off, but you're not going to go from 100 to 0 instantaneously. You're just going to keep going
Hi, JK.
because you don't have all that momentum transfer. So when you have glancing contacts, you can have much higher speeds without a lot of damage to the car because you're only in momentary contact and it's a glancing type hit.
You mentioned about potential
How are you?
damage to a car. How about potential damage to the pedestrian?
It's the same thing. So when you have a glancing hit to a pedestrian, this is referred to as a fender vault. In this case, they call it a fender. Fenders on the front of cars because most pedestrian impacts involve the front of cars. In this case, it would be called a quarter panel vault, which means you're kind of vaulting off the corner of the car. Those are much more complicated because you don't have that common velocity that I referred to. So it's difficult to calculate the exact speeds at which the vehicle contacted.
Honestly, Caroline, not much. They were trying to get the slides up for quite a while.
Without a whole bunch of information in that type of crash. If the impact had occurred in the center of the vehicle and we knew where the point of impact was and the point of rest, we'd have a much better chance of determining how fast the vehicle was going. But when you have just a corner clipping or glancing, it makes it more difficult to determine, even when you have an area of impact, which is where the person was when they got hit,
Sam,
and a
look.
point of rest where they've landed, makes it more difficult for glancing contacts because you have that side swipe problem where they don't obtain what's called common velocity.
And what are some of the other difficulties in attaining specificity in a side swipe or being hit by a quarter panel as opposed to a fender?
So for a pedestrian, correct?
Yes.
So pedestrian impacts and how you move post-impact are very sensitive to your exact body position. For example, whether your right
Sam, this came today. This is Rihanna's perfume.
foot is on the ground or off the ground, whether your left foot is on the ground, off the ground, whether you jump up in response to the crash. Simply
Love.
raising and lowering your arm changes the amount of rotation that's going to happen. Post-impact motion of the person. So
Right? I agree.
cadavers, crash dummies.
No, I can't afford expensive. I'm on a fixed income. If you guys message me asking me to link you, I will link you. It's affordable.
Don't have any muscle reaction. So the motion of a crash dummy is just going to be like you're hitting a dead body, to where people will step, try and regain their balance if possible,
Thank you for the follows.
will do additional activities that alters where they come to rest.
In your studies of direct pedestrian collisions by front or back bumper, as opposed to side swipe or clipping somebody, is there a similarity or difference in type of injuries that you see?
Yes.
And what is the difference?
So in direct centralized impacts, you tend to get much more severe injuries. Really what's occurring is you're getting that momentum transfer. So it's
Guys, we got 10 more minutes. We got to get to 40 heart me's. If you guys haven't sent them and you can, it will be greatly appreciated.
more, you're accelerating the person up to the vehicle. They can wrap onto the side in front of the vehicle at higher severities. Their head will hit the hood, their head will hit the rear of the vehicle. So when you have that direct contact, there's actually more momentum transferred to the actual occupant. There's more applied force to the occupant as well.
Thanks, guys.
When you see direct impacts, is
Lori.
there ever the existence of lower body extremity injuries, broken bones in the legs?
So there can be both, depending, and again, it's very sensitive to where the foot is on the ground, whether the foot's on the ground, as well as the severity of the crash. In the presentation that I gave at the Accident Reconstruction Collision Safety Institute on pedestrian injuries, I went through all the literature on lower extremity injuries and looked at what parameters affected that. And so depending on how it was loaded, some at 15 miles an hour had no injuries. Some at 15 miles an hour had some fractures. It depended on how exactly the foot was loaded.
Is it uncommon in sideswipe pedestrian accidents to see no lower body broken bone?
No, it is not uncommon.
Have you had cases that you've studied or been involved with where you've studied the effect of a sideswipe or a clipping impact where there's an absence of broken bones in the lower body extremities?
Yes.
I'd ask you to turn to slide 139, please.
20 more heartbeats, guys, and we got the BIS goal knocked out. We need to get to our 21st goal today.
Oh, sorry. I fixed those other two slides.
Okay. Could you share with the jury what this represents?
Sure. So this was a trial that I was involved with in downtown Los Angeles. I've redacted the name at the top, but this was an instance where we had, this is a image from the police report. Oh, let me see if I can.
Oh, he doesn't, trust me. Not for a few weeks yet, Veronica.
So AOI in this diagram stands for area of impact. That's where the pedestrian was when they got hit. AOR is area of rest. And you can see we have information on exactly how far the pedestrian was thrown.
Down here.
Then on the right-hand side, we have photographs showing the impact to the pedestrian. This was determined by experts on both sides of this case to be between a 25 to 35 mile an hour impact. And then what you see is a close-up on the bottom slide of where there was DNA transfers, hair and tissue samples on the vehicle from the individual that was hit by the vehicle.
Next slide, please. And what does this represent?
So this is the decedent in the case, the person that was hit. He was killed at the scene. What you see on the left-hand image, on the left-hand image is he had a massive laceration to his right forearm, but it didn't break his arm. There was no broken bones in his arm. On the right-hand side of this image, you see the autopsy report. What you'll notice is he had red marks on his leg, the buttocks, but he had no leg fractures. And again, this individual was hit at between 25 to 35 miles an hour.
Can you expand that? I'm sorry.
Yes, yes, sure.
Do you want that expanded like other times?
There you go.
Thank you. I'm sorry to interrupt you.
Yeah, no, my pleasure. Thank you.
Bringing in images from another crash to show someone so badly hurt is another way to influence the juror, and it shouldn't be allowed.
So at the top, he had a severe brain injury, which again is the most common injury in pedestrian crashes. He did have fractures of the right 11th and 12th rib and a liver laceration. If you look at the extremities, it says right upper extremity. Again, that's from the shoulder to the end of the hand. Extremity wound with vascular injury. So no fractures.
I know Nini was too.
If you look where I was talking about the multiple abrasions, so when they're looking at the lower extremities, they're noting a number of red marks, but there was notably no fractures to the lower extremities.
Not only is the environment different for what they're showing of this victim person from another case that we can't tell who they are, their face or anything, what he did was recreated in a totally different state too. So, yeah, the person of the year.
Thank you. You can take that down, please.
Guys, we've got about 4 more minutes to get 6 more heart-me's. Is it 6? I can't. I need my glasses. They're in the living room. We need more heart-me's. I think it was 15. No, wait. I cannot see. Babe, will you bring my glasses in, please? Thank you for the follow. All right, I think we're good now. No more pop-up bodies.
Dr. Welch, regarding your analysis of the data
Is it
and the evidence in
15?
this
Thank you.
case,
I can't see.
do you have an opinion to a reasonable degree of engineering certainty whether the absence of lower body brakes to Mr. O'Keefe is consistent with the defendant's Lexus impacting in a sideswipe
Somebody
or
mind,
clipping Mr. O'Keefe?
Yes, you could definitely have this type of impact and not have anything beyond, say, red marks to the lower extremity.
Thank you, Dr. Welcher.
My
Your
pleasure.
Honor, I would move the evidence subject to redactions. Dr. Welcher's PowerPoint presentation.
That's by agreement, Mr. Wilson.
Good morning. Guys, we still need 12 more heart-me's. It just cost 1 gold coin. Just one. If we can get our goal, there's 142 in here. If we could get that goal, I'd really appreciate it. It's just 1 coin. Thank you, Lacey. Thank you, Presley. Now it's time for a let's see. Thank you guys so much. I appreciate it.
Put in both the flash drive
Ignore.
and the notebook.
Representation, it's.
Now I can see.
Same as that I know.
So let's put them both together now and decide later.
I can see perfectly now. Now that I got my glasses on.
Those 2 slides are incorrect on the flash drive.
Yeah,
Okay, so we'll switch that.
that's.
Who is going to be our final 8? We just need 8 of you to send your heart-me's. Just 8 of you. Who will be the final? Okay, the final 7. Thank you. We need 7 more. You can only send a heart-me once a day. It doesn't let you send it more than once. I need 7 more heart-me's, guys. 7 more. Thank you, Kennedy. 6 more. We could do this. We got a minute. We only have 1 minute, you guys. We only have 1 minute to hit this goal. 1 minute. Can you guys do me a favor and please send your heart-me's? Thank you, T-Dragon. 5 more, guys. Please send me your heart-me's. We want to hit this flash goal out. Come on. We got this. 5 heart-me's in 1 minute. There's one. Halsey, thank you. Danielle, thank you. Come on, guys, we're close. Thank you, Jill. 2 more. I need 2 from anybody. Robbie, thank you. 1 more. I just need 1 more. Just 1. Anybody. 1 more. We could do this. We can get to 21. Hi, Patricia. Can you send your heart me? We just need 1 and we need it in 30 seconds. Anybody can send it. Anybody. We got it. Thank you so much, Mo. I appreciate it. Thank you, guys. We finally got our 21st flash goal knocked out. Great job, team. Great job. I was getting nervous there.
What exhibit number is it? 206, thank you.
6206.
Thank you guys very much. You're just in time. Alessi's just now getting the question. Thank you, Tabri.
All right, Mr. Lessie, whenever you are ready.
Your Honor, if I have a moment to set up.
Sure.
It said that we didn't achieve it. It said we did not achieve it. Maybe it's a glitch? Well, it said it achieved 2, and then it switched to did not achieve. I'm counting it, though. Yeah, it showed it for me, too. I think it maybe glitched. I made new stickers, Cat. Has to be. Thank you, Michelle. And the ceiling fan is in there, too.
Morning, Dr. Welcher.
Good morning. We haven't been formally introduced. Your whole name?
Robert Alessi, sir.
Robert Lessie. Nice to meet you.
Nice to meet you.
Did you catch that? Thank you so much. I want you guys to hear that one more time.
Morning, Dr. Welcher.
Good morning. We haven't been formally introduced. Your whole name?
Robert Alessi, sir.
Robert Lessie. Nice to meet you.
Nice to meet you.
He is very arrogant. He is trying to undermine him. You're 100% right. I know. I wonder if he was told to do that. Can't help but wonder. Never, JK. JK, I've never seen that, ever.
Dr. Welcher, the area in which you engage can also include, and I believe you used the term on direct, forensics, correct?
Yeah.
Do you engage in any forensic activity in your profession?
Yes, the general umbrella of you basically coming in, giving scientific evidence in court applies to forensics. So my main job is action reconstruction and biomechanics. And so that's what I do. Sometimes it doesn't involve court. When it goes to court, that's generally forensics.
Right. So
And guys, especially my moderators, what we're doing today, I'm not going to entertain the trolls. So if you have someone that's a troll coming in saying she's not guilty and it's a troll, please block them. Please don't engage with them, guys. We don't want to engage.
So you're here today, that is my question. You're here today, at least in part, with regard to forensics, correct? Because forensics is the Latin term for it is basically you're going to have some type of court or jury presentation. It's for law, correct? Would you agree with that? It's for law, forensics?
I mean, exactly the way you asked that, no. It's for engineering and it's for biomechanics. It's in the court of law, I think is what you're asking.
That's exactly it.
Okay, yes, certainly for the court of law,
It
yes.
ends up to a court of law, and forensics is a common term.
Yes, sir.
So it relates to, or it's used in, or it's suitable for a court of law, the analysis. You'd agree with that? It's a general principle?
Yes.
Not a trick question. Okay. And so in forensics, what you're doing, among other things, is you're applying the scientific method and principles in here in a criminal matter, correct?
Yeah, you're trying to apply as much as possible.
Right. And so the primary goal of forensic science is to uncover the truth and to provide objective evidence that can be presented in court.
That is generally correct. Again, there are elements, for example, this analysis that are relying sort of on subjective evidence, like the testimonial, the witness statements. So it's not solely based, but ideally you'd want it as much as possible based on objective data.
So you would agree that
Those are subscriber stickers. So if you subscribe, you can use all the stickers. We've got a lot of them. A lot of them.
truth and objective evidence is part of the presentation in terms of information for forensics in a court
That
of
thing
law?
right there.
Certainly objective information, truth sometimes, again, can be subjective.
Oh, so you don't believe
I
truth?
agree.
You believe sometimes truth applies and sometimes
no.
it doesn't?
If you know for a fact it is true, but if you take someone's deposition testimony, you have to look at it relative to the evidence, and it's either consistent with the evidence or not.
Okay, so now let's go to your direct examination that you just went through.
Please.
Hopefully this is fairly straightforward. You have testified to, and it's varied a bit, a reasonable degree of engineering certainty. Is that correct?
Correct.
You've also, have you used the word sometimes to reasonable degree of scientific certainty?
Thank you for the follow.
I may have.
Right. So
I don't know.
in terms of your role as a biomechanical engineer and accident reconstructionist, is it important to engage in a critical analysis of the data?
Critical analysis? Yeah, I think it's important to have a critical analysis. You want to try and look at it from all sides, consider all possibilities.
So it is therefore important to try to review the data as objectively as possible. You had mentioned sometimes subjectivity comes in, but I understand the goal is to try to look at it as objectively as possible, correct?
Correct.
Now, you stated with respect to your
This is the
conclusions
defense,
early
Kimmy.
on in your direct testimony and your analysis that you don't, and I think I've got it quoted, you don't have a dog in the fight. Is that what you said, sir?
I did.
And that you, quote, don't care, end quote, about the outcome. That's what you made a point of saying in the beginning,
That is
correct?
100% correct.
Now, you simply follow the data. Is that correct?
I try to do that.
You try to do that.
I'm not perfect, so
Okay.
I do my best. I believe I've done it here.
Okay, so
Keep thinking that.
in terms of you've agreed that you apply the scientific method, so I want to see if you're in agreement generally so the jury can understand what the
I can now.
scientific method is. Are you familiar with NIST, National Institute?
Yes.
Yeah, so would you agree with this definition of the scientific method? The systematic pursuit of knowledge involving the recognition and definition of a problem, the collection of data through observation and experimentation, analysis of the data, the formulation, evaluation, and testing of hypotheses, and where possible, the selection of a final hypothesis. Is that
Oh,
a general?
when they start their case, I got it. Yeah, they haven't started yet, but word is it's gonna possibly happen today or tomorrow. And I posted in our Facebook group the witness list. I also put it on my TikTok page, so the defense's witness list is up.
General fair statement of the scientific
Thank you for
method?
the follow.
So for forensics, you'd have to add in the testimonial evidence aspect of it. So those are testimonial or things are in evidence. So frequently there's one or two versions and you're trying to match which version is most consistent with the evidence.
Okay, adding that to what I stated relative to NIST, you would agree that evaluation and testing of hypotheses and where possible the selection of a final hypothesis is the scientific method, correct?
Generally,
The Facebook page is Criminal Musings. Good
Is
point.
it correct that a proper
point, Aaron.
biomechanical injury analysis utilizes a sound scientific methodology that's
You
been
better not.
subjected to peer reviewed and a publication that's been generally accepted in the engineering community?
Well, I can't. So this, I've done my analysis here, biomechanical analysis. I can't submit this analysis to peer review. I'm not allowed to give this to people outside the court. So there would be no way for me to submit my analysis for peer review. So this occurs forensics all the time. The forensic analysis in court generally never goes under a peer review process. The methodologies underneath it, and looking at, like, for example, I think I referenced 25 papers in my report. That goes to the issue of trying to follow the science. 26.
So I think you may have misunderstood my question, sir. I was talking about your methodology, your biomechanical injury methodology. The methodology that you use and apply is to be subject to peer review and general acceptance in the engineering community. Is that correct?
So I have no way of publishing this analysis.
I'm sorry, sir,
to
to
get
interrupt
peer,
you.
I need to.
Go ahead and answer your question.
You're asked peer reviewed, like you said, means I give it to my peers. I send it out to somebody to review for the scientific method. That's what the peer review process is. So I will gladly send this out to peer review with the court's permission, but I haven't and cannot do that.
Sir, my question is not your analysis here in this case.
Oh.
My question regards the methodology that you use here. Is the methodology, you said 26 references, right? My question is simply, is the methodology that you used for your analysis in this manner?
Hi, Crystal.
Is the methodology for a proper biomechanical analysis? Should that methodology be generally accepted in the engineering community?
I think with the forensic.
Which guy? Alessi, the one asking the questions? Because he's passionate about what he's doing and he believes that his client is innocent. I'd be passionate too if I saw what she had been put through.
Forensic application, yes.
Okay, that's
The one answering because he's a know-it-all and thinks he knows everything. Alessi has him though. He's got him.
that was my question, just the methodology. Thank you.
You're welcome.
Got you.
Now, the scientific method that you've used in this case, part of the use of scientific method, the purpose is to avoid what is called bias in the scientific method, right? Not cultural bias, but
He's my second husband, actually.
just bias in terms of the application of methodologies and principles. You would agree that's a pretty fundamental purpose of the scientific method is to avoid biases?
Right, Danielle?
The purpose of the scientific method is to get the most logical and correct answer without bias.
Exactly. To do it apply the scientific method without bias being part of the application of the method, correct?
That's hopefully what you could do.
That's hopefully what you can do. That is the goal, right?
That is one of many goals, yes.
So, are you familiar with the term confirmation bias?
I am.
And that relates, confirmation bias is part of a larger term. Are you familiar with cognitive bias?
Generally, I'm not a human factors expert, though.
Pardon me?
I'm not a human factors expert.
All right, biases are, don't you agree that cognitive biases
Not yet.
are not just for one category? You would agree it applies to medical analyses, it applies to doctors doing studies, engineers doing studies, and other scientists doing studies?
So I'm not a cognitive expert. I think I would generally agree with it, but I don't want to step out of my lane. I'm not an expert on cognitive. I can talk to you about confirmation.
But you had no problem talking about causes of death yesterday, did you, sir?
Bias, if
Fair.
you like.
Let's talk about confirmation bias. Now, confirmation bias
I know.
is actually when someone selectively gathers and interprets evidence to confirm one or another's belief,
I agree, Marie.
as well as neglecting evidence that contradicts those beliefs. Is that a fair statement of confirmation bias?
That is a statement. Yeah, it could be broader, but sure.
But you would agree that that is generally correct,
Generally,
what
yes.
confirmation bias is. And an example
This guy reminds me of my ex-husband.
of confirmation bias is not considering alternative hypotheses once an initial hypothesis has been selected, even though data and information might contradict the initial hypothesis. Is that an example of confirmation bias?
That could be yes.
And confirmation bias is antithetical. It's against the scientific method. It's to be avoided, correct?
You would like to avoid it, yes.
1 second, I'll put it back.
Are you familiar with the term failure analysis?
Generally, you might need to define how you're using it for me.
Sure. So is failure analysis the enablement of a scientific examination of an alleged incident by beginning at the undesired consequences? Is that a fair use of that phrase?
I was thinking something different, like a piece of metal failing. I guess it could fall into that category.
Okay. And would you agree that the first question, or one of the first questions that are to be asked by a biomechanical engineer when conducting an analysis of, say, an injury is, how did this happen? Is that one of the first few questions that you ask?
No, that's usually the last question.
Oh, so for you...
So hold on a second.
Okay, I'm
Generally,
sorry.
what you want to do is gather data.
Hold on. Are you going to tell our husband to hold the hell on? No.
You want to know what injuries there are, what evidence there is, like, for example, on the vehicles. And then the very last thing you want to know or
I don't see
define
him on
is,
this list.
given all that information, how did it happen? So that's the end.
I think you may have misunderstood my question, sir. I wasn't talking about the method or the process. I was talking about when you get to answering questions, whenever that is in the process. Isn't one of the questions, and maybe one of the first questions, how did this happen?
No, that's not one of the first questions. And one of the first questions is, where's the damage? What are the injuries? What's the evidence? What black box or tech stream data do we have? What physical evidence was at the scene? So that is certainly not one. It is a question, but that question is at or near the end.
Isn't every one of the questions that you just mentioned part of the data gathering?
Correct. But,
Okay.
but when you're gathering data, you're always asking yourself questions along the way, like, what is this? Where did it come from?
But you would agree that for you at least some point, it's how did this happen, correct?
Yes.
And don't you ask that question to come up with hypotheses?
I generally have many working hypotheses as I'm working on the case. And then as the evidence comes in, I'm applying that to my hypotheses and either accepting or rejecting the hypotheses based upon the factual information.
Sir, how then is it just a matter of logic or a syllogism? If you don't ask the question, how did this happen, until the end, how do you then not get your hypotheses up front when, under the scientific method, you should be having different hypotheses up front? How is it that you ask the how did it happen at the end
Sure are, Ashley.
and not go through hypotheses in the beginning? Can you help me with that logic?
Sure, I guess I misunderstood. Like, I was trying to give you an answer to how it happened. So when you're answering how it happened, or you want to be able to answer that question, you want to make sure you've looked at the totality of the data, accepted, rejected, things as they came along, to be able to answer that final question, how did it happen? But along the way, like, for example, a right eye laceration, you want to know how that happened. So you look for the evidence of how that may have happened.
So you would agree then that questions of how it happened formulating and identifying hypotheses does and can happen toward the beginning of the analysis. It doesn't happen at the end all the time. Would you agree with that?
So the ultimate question of how did it happen happens at the end. The questions about the elements of what occurred to make it happen, those occur at the beginning, middle, all along the way.
You would agree that creating hypotheses occurs more toward the beginning than toward the end of the analysis. Is that correct?
There are probably more hypotheses in the beginning, but I am continually forming, looking at hypotheses, either accepting or rejecting them upon the evidence.
So you would agree that the creation of hypotheses does occur more toward the beginning of the analysis. You would agree with that?
There are more towards the beginning. The process occurs throughout the whole investigation.
Right. I'm asking about the hypotheses, sir. You would agree that the hypotheses occur more toward the beginning than the end, just the hypotheses.
So I don't know if you and I are saying different things. More hypotheses in the beginning because you have more questions in the beginning. You continue to form hypotheses as the data presents itself. So you don't stop the formation of hypotheses. It's just as you get more evidence, you window down the number of questions.
Maybe I can, just this last question, make it clearer for you, sir. You would agree, not analysis, which you added, as I heard it to the last part, just hypotheses. Mm-hmm. You would agree that even though hypotheses can be created and changed perhaps all the way up to the end, mm-hmm. you would agree that it's important in the analysis to create at least some hypotheses, plural, in the beginning, correct?
Yes.
Thank you for the follow. I'm a nervous eater. I have my cashews.
Once you create these hypotheses, would you agree that those hypotheses should be tested?
So if you take the word testing to mean testing compared to testimony, compared to physical evidence, yes.
And when you test those hypotheses, isn't it often the case
Thank you for the follow.
that particularly in your line of work, the one that most consistently produces the same injury will emerge as the mechanism of injury?
I guess it depends on the scientific evidence behind it. Again, sometimes we get very unique injuries.
So my question, sir, is this. Mm-hmm. Isn't it the case that when you have multiple hypotheses, the one that most, out of all of them, it's a relative thing, the one that most consistently produces the same injury emerges as the mechanism of injury? Is that a fair statement?
I think generally, again, it's on a case-by-case basis. You have to look at the science and the facts of which
Who was AOC?
you're basing it upon. I think as a general premise, what you're saying is accurate.
Okay,
but there's exceptions.
Fair enough. But it's a general principle
Sure.
with some exceptions. That's a fair statement, correct?
Yes, sir.
We're going to have several topics, sir, and what I'm going to try to do to make it a little clearer is I'm going to say when I'm switching topics.
Oh, good.
So what I'd like to do now is switch topics.
Okay.
You're aware that the Massachusetts State Police has troopers who specialize in accident reconstruction, correct?
Yes.
And there are troopers within the Massachusetts State Police Collision Analysis and Reconstruction section whose sole responsibility is to engage in accident reconstruction. Do you know that?
I do not know that.
Do you know that there are troopers within the Massachusetts State Police Collision Analysis and Reconstruction section who engage in accident reconstruction?
just based on what I've seen in this case.
Right, based upon what you've seen in the case, that's a fair statement.
And I just know that those people are doing it.
Are you familiar with a Massachusetts state trooper named Joseph Paul, Paul?
Yes.
And you
Well,
know,
I'm familiar with his reports. I don't know the man.
okay, familiar with Trooper Paul through his reports in this case, correct?
Correct.
And are you aware that he was assigned by lead investigator, former Trooper Michael Proctor, to be a constructionist in this case on January 29th of 2022, as evidenced by that report or those reports of Trooper Paul? Do you know that?
Well, you put a lot of things in there. I know he issued a reconstruction report. I don't know who told him to do it. So the
User, I need you to be a bit more specific than that. I'm going to be off camera eating my sandwich.
first party question, I don't know, but I did see a reconstruction report from him.
You were retained, and so do you recall, is it the date, January 29th of 2022, is that a rough time period of him being assigned, or you don't know when he was assigned?
Don't know. That might have been in his report, but I wouldn't have paid attention to when he received an assignment.
Do you know when the date of the first report of Trooper Joseph Paul in this case?
I can pull it up. I do not know off the top of my head.
You know that the date of the incident in question is January 29th, 2022, correct?
Correct.
Yet your firm and you were retained for this case by the Commonwealth 2.5 years after the incident in question. You were retained, your firm, on September 23rd, 2024. Is that correct, sir?
No, I believe we were retained a couple days before that.
A couple
Guys, if there's anything that you need to get or that you need to turn your volume up, now is the time to have your volume up. Trust me.
days. Okay.
Right.
So
Actually, I might be able to find out if you'd like me to look at the documents.
it's not all that important. You would say it's within a week of September 23rd, 2000. It was in September of 2024.
I believe it was in September, yes.
Right,
I would
so-
want to double check.
That's 2.5 years from the date of the incident in question, if I did the math right, correct?
Oh, I never thought about it. Yeah, approximately.
And as we just discussed, and you stated on your direct examination, you have no dog in this fight, correct?
Correct.
On November 5th of 2024, your firm Aperture was paid $44,500 by the Norfolk County District Attorney's Office to conduct work that was at least similar to the work of Trooper Paul, correct?
I have no idea. I don't get the billing or the statements.
Do you recall whether Aperture has, well, do you believe Aperture is working for free in this matter?
Oh, no, I don't believe that. No,
So
we're an engineering company. We bill for our time. So
you know that Aperture is getting paid for its work in this case, correct?
we are billing for our analysis work.
Well,
It wasn't just $44,000, you guys. Keep listening.
you're not just billing, you're billing and getting paid, correct?
So I have not seen any of the payments. I would assume that we're getting paid, but I don't know that.
Sir, you are a senior vice president of Aperture, are you not?
I am.
You would know, wouldn't you, if your firm was not getting paid for work since September 23rd of 2024, wouldn't you?
No, probably not.
Press in
Usually
those
it takes, 9, 10, 12 months of not getting paid before the accounting department reaches out to me.
Exactly. So you've been on this for 2.5 years. So if it would take 9 months or 12 months, if you weren't getting paid, you would have been notified by that by now, correct? according to your own answer you just gave.
I've not been on this case for 2.5 years.
I'm sorry, sir. Let me go back to the question of payment.
Hold on. You said I've been on this case for 2.5 years. I
Hold
was
on.
retained in September 17th-ish of 2024. So that's what, less than a year ago.
Understood. I'm
you
moving
said
on
2
to the
years,
next
dude.
question because I want to move away from that discussion and just
Okay.
go right to
Yeah, he
the
said
bill.
hold on.
You, as you sit here today, do not have a recollection of whether Aperture has been paid. Is that your testimony?
It has nothing to do with recollection. I'm not part of that process. We have an accounting department. I don't have any involvement in that.
Are you, so is your testimony you have no knowledge about any contractual relationship between Aperture and the Commonwealth?
Oh, no. I was sent a contract by the Commonwealth to sign, so I'm aware of the contractual agreement, but the day-to-day or month-to-month invoicing and billing, I'm not involved in that.
Okay, so you're aware there's a contract between Aperture and the Commonwealth,
I signed it.
and you signed it. And wasn't that contract obligating the Commonwealth to pay for the services of Aperture? Isn't that the purpose of the contract, in part?
In part, sure.
Yeah, it's a legal obligation of the Commonwealth. Your firm does work and the Commonwealth pays for it, correct?
That's the idea.
Right. And so you know about that contract because you signed it.
Correct.
Also, you testified on direct that there was a purchase of a Lexus exemplar for your testing.
Correct.
Who pays for that Lexus exemplar?
Aperture?
And is that then cost passed on to the Commonwealth?
No.
So you pay for the Lexus, you don't pass that cost on, correct?
So what we're doing is we paid for the Lexus. We're keeping it till the trial's over. We're selling it and charging the Commonwealth the difference in the price.
Exactly. That was where I was going, sir. So,
But they're only paying the difference.
Oh, wait,
So,
there's
and in
more.
theory, if we sell it for more in California, then we'll reduce the bill.
okay, I don't want to speculate. I just
There's
wanted
more.
to see what the obligation was. So
The
if-
obligation is the difference.
Exactly. So the obligation is the difference. Are you aware that on April 5th, 2025, the Norfolk County District Attorney's Office amended your contract? Are you aware of that, sir?
I am.
And isn't it the case that that amendment authorized the amount of $325,000 to be paid to Aperture? Isn't that what that amendment contract states?
I believe that's correct.
So the Commonwealth is obligated to pay at least $325,000. And is that correct?
That is you're asking me a legal opinion now about a contract. That is my understanding of how contracts work, but I'm certainly not an attorney.
And on top of that, are you aware that Aperture has been already paid $44,510 for its work? Are you aware of that?
The second time you asked me, no, I'm not aware of anything we've been paid.
And as you stated yourself, those amounts reflect, as you say,
Catnip, you heard that right?
less than 6 months worth of work?
That's not what I said.
Well, no, my question is, you've been on the case, you said, since September of 2024, when we were talking about dates, you said that was about 6 months that your firm's been retained. Did I have your answer correct about how long you've been on it?
I guess it's closer to 8 months.
All right, so 8 months. So for 8 months of work, about $400,000. Is that correct?
So there's 3 offices working on the case. There's the Boston office, there's Mr. Burgess's office, and there's my office in Long Beach. I only know about the billing from my office.
But you signed the contract on behalf of all of Aperture, not just
Kevin.
your office, correct?
That I don't know, but I definitely did sign a contract.
Would it refresh your recollection as to who you signed the contract on behalf of, whether it's all of Aperture and all offices, if I showed you the contract?
Sure.
May I put you on?
Yes.
May I put you on?
Yes.
Thank you.
How many of you are from Canton? I'd be pissed right now.
Sir, may I?
Yeah, could you direct me so we're not wasting time?
Well, it's your, what I'd like to do, Your Honor.
Did you hear that? You're not going to talk to our husband that way.
That I don't know, but I definitely did sign a contract.
Would it refresh your recollection as to who you signed the contract on behalf of, whether it's all of Aperture and all offices, if I showed you the contract?
Sure.
May I put you on?
Yes.
Listen,
May I put you on?
Yes.
Thank you. Sir, may I?
Yeah, could you direct me so we're not wasting time?
Well, it's your, what I'd like to do, with the witness, Your Honor, is just ask the witness a question with regard.
and in case you guys were wondering, yes, AJ was laughing at that. I would show you, but it's like this big, so you can't really see. Yes, AJ and Karen are laughing.
Why don't you just take a look at that, Dr. Burgess?
Thank you, Your Honor.
Not wasting time, huh? You mean the way you did yesterday? Yeah, AJ's still laughing. He can't believe he said that.
And then when he's done, Mr. Lessie, you can take it back to the podium.
Yes, Your Honor. Thank you.
I'm gonna go back to eat my sandwich now that we're past this part. I haven't seen it from here on. I'm still here though, I'm just off screen.
There you go.
Can I ask a few more questions before I do that, Your Honor, for foundation purposes, if I wanted more than refresh?
All right.
Would you like me to start with
So-
refresh?
Go ahead and start with refresh. Go back to the podium, please.
Sure.
Thank you.
Thank you, Your Honor. Dr. Welcher, does that refresh your recollection as to the contract you signed on behalf of Aperture with the Commonwealth?
So it lists the legal address as my office. So for my office, yes.
So are you saying that therefore, and did you see the amount that was in the contract? Did that refresh your recollection?
Oh, no, I didn't even look at that.
Do you recall the amount that of obligation
Yes,
that the contract relates to in this document? Do you recall that?
You just asked me that earlier, and I'm taking what you said to be true. So I was like $325,000. I have no reason to disbelieve that.
And is there also a total, do you recall the total maximum obligation for the contract that's listed in the contract? You
No.
recall it? May I approach your Honor?
Okay.
And Dr. Welcher, I am now going to, you asked me last time, I hope this is helpful. You said, please point to the applicable part so we can do it faster. I am now pointing to that part and see if you can just look at that and see whether this refreshes your recollection on the maximum obligation of the contract pursuant to this contract. Without saying what it is, just does it refresh your recollection?
No, but I don't have any reason to believe it's not correct. And that is my signature on it.
Right. And we got started on this conversation tying it to, well, we got started on this conversation with regard to a statement you made earlier in your direct that you didn't have any dog in the hunt. You recall that statement in the beginning of your direct testimony.
You misquoted me. I don't have any dog in the fight.
You don't have any dog in the fight.
Correct.
Thank you. Now, switching topics.
Okay.
You submitted an updated PowerPoint presentation.
You guys, I can't make this shit up.
The one that we that you went over on your direct examination. You created that presentation
Right.
quite recently, correct, sir?
The updated one was where I had redacted or taken out slides. So in terms of taking out slides, I did add one alternative path a couple weeks ago.
Okay, my question, sir, is this. The updated presentation, we'll get to the changes later, but the updated presentation, you created just how many days ago?
I'm gonna say weeks ago.
Weeks, 2 weeks?
I don't actually know without looking at the documents.
Well, was it more than 3 weeks ago that you created it?
I still don't know without looking at the documents.
Do you know when the trial started in this matter, sir?
I do not.
Assume the trial started approximately April 22nd of 2024.
Okay.
Did you create your updated presentation before or after April 22nd of 2024?
I don't know.
Do you know when?
Hold on one second. Dr. Welcher, I'd ask that you not do.
Not look at, okay, I was gonna try and answer his question. My apologies. I will shut it down.
Thank you.
You're welcome.
If I may, Your Honor,
Yeah.
say it.
Trying to look at his laptop.
Are you able to determine when you created the updated presentation?
I think so. That's what I was attempting to
Your
do.
Honor, may he do that?
Yes, I'm going to see Counselor Tyball while you pull that up,
Thank you,
please.
Don't worry, and here we practice patience with parameters. Meaning we don't have patience.
Clouds begin to develop, we'll be expecting around a 50 to 60% chance of some shower activity on that.
Mr. Alessi, I need you over there. So,
Right, yep.
and once you get that answer, I'm going to ask you to shut your computer down, or at least put down the cover.
How about it?
Thank you. All right, so you can answer Mr. Alessi's question.
Thank you, Your Honor.
Could you give me the question again, please?
Yes. When did you create the updated presentation that you reviewed in your direct testimony?
So that addition I made was taken out. It wasn't in my direct
Sir,
testimony.
If you can just hear my question, it's this. The version of the presentation that you put on the screen, when did you create that version? I'm just looking for a date.
So to answer your question about the version on the screen, I created that yesterday when the judge asked me to take off some of the headers. So yesterday.
Okay, good. Now, the version before that you created yesterday, when did you create that version?
The day before.
And then the version before that one, when did you create that?
I mean, I save it every day.
Understood.
So every day.
So you've changed the presentation every day since when?
No, I don't think I've changed the presentation every day.
That's my question. My question is, how many times have you changed it within the last 2 weeks, your presentation?
Let me try and cut to the chase here.
Sure.
That slide was added on May 13th, and then it was taken out before I presented it here. So it was not in my presentation here.
Right. So thank you for that answer. So
You're
here's
welcome.
the question. Your first version, as I understand it, of the slide presentation was January 30th, 2025. Is that correct?
Correct.
When was the next time after January 30th, 2025 that you changed that presentation?
May 13th.
Assuming the trial started April 22nd of 2025, you changed your PowerPoint presentation during this trial, correct?
Correct.
And how many times did you change your presentation after April 22nd of 2025?
Well, the last time they changed it was like 10 minutes ago. So in response to various discussions, I've been making continuous changes to it.
I want to make sure you finish your answer, so I didn't
No,
interrupt.
I'm not sure how much granularity you want to that answer.
Right, so you created on January 30th, 2020.
This trial's expected to last 8 weeks, so we're gonna be a lot of nerves for a while.
25, you made your,
13th.
pardon me?
Oh, the original one. Sorry,
Yeah.
January 30th, modified May 13th.
Right, if I could finish my question, I might be able to shortcut this, thank you. So you created the original one on January 30th, 2025, you made your first amendment May 13th of 2025, and then before you sat for your testimony, which was yesterday, correct? That was the first time you sat for your testimony.
That is correct. I was here yesterday.
Days get foggy when we're in a courtroom, but it was yesterday. How many times had you changed your presentation from January 30th, 2025 until when you first walked in the courthouse yesterday?
Do you mind if I count?
Not at all.
So there was the May 13th change. Half of that was in response to objections from the defense. I had to add all the paths to where everything was. Then when I got out here, Mr. Brandon asked me to take out references to evidence about statements that I was not allowed to present. So that would have been within the last 3 days. And then I've modified it a couple times today based on rulings from the judge.
Okay, let's break that down. You said half of the changes you made on May 13th related to what? Because I want to know about the other half.
Sure, there was two changes. I added the extra path of 138, and then I was told that the defense was having problems with my PowerPoint, so I had to go in and add the paths to every single slide about where the evidence came from, because they were saying I didn't provide everything, and I had provided everything.
All right. So
That was the second half.
got it. I want to go to the first half, sir.
Sure.
And I'm going to try to shortcut this.
Please.
And if I'm not clear, you just let me know. I want to talk about the first half. You called it, I didn't hear it. It was like, did you say path?
Path.
P-A-T-H?
Correct. The path Miss Reed was driving.
Right. What you made the change for May 13th, that first half, that wasn't something that was triggered by the defense. That was something irrespective of the defense, correct?
It was based upon her statements. Is she part of the defense?
All right, so that's what I wanted to get to. You changed the first half based upon statements you allege that Ms. Reed made. Is that correct?
It's because I changed one slide. There was 130 slides originally, or something like that. So half of the changes on that day, which was one slide, I added one line to the bottom of the previous slide.
Did you consider that change significant?
No.
Well, then why did you make it in the middle of trial if it wasn't significant? Why didn't you just leave it off and then discuss it in terms of testimony?
So A, it ultimately was left off. B, because it was insignificant and I didn't need to have it.
Why
So
do you get to decide what's insignificant and not?
the way it got presented was exactly the way it was before May 13th. So it didn't change anything.
But it was significant enough for you to make a change to your presentation, correct?
So my goal is to be as accurate as possible. So when I saw the
sure?
path that I gave, the way she could drive, I gave the possible paths. That was one of the possible paths that hadn't originally been included. So in striving to be as accurate as possible, including as much information as I could, I wanted to make sure I included that.
Judson Welcher, he is from Aperture.
So you were striving. The clip that you used to make the change, you say you made the change based upon a clip you observed with regard to Ms. Reed. Is that correct?
I believe that, yes, that is correct.
Do you know that clip has been in existence for months?
I don't believe I got it until April.
So a clip that
Guys, do me a favor and please state, in my opinion, when you're stating something that's not fact, I don't need people saying Michelle's misinformationing. Thank you.
assume the clip's been in existence for months. You just got the clip.
Dr. Welch, I have to ask you
Oh, I'm
not to
sorry.
refer
I'm trying to be helpful.
He's in his
Yeah,
laptop
let
again.
me close it. Sorry. I was trying to answer his question.
Snoozing, who you talking to? Are you saying shh because you're secretly watching us and you're not supposed to be? I think that's what you're saying.
So I'm going to ask you to close the topic.
Yeah, that's probably a good idea.
Just flat that. Thank you.
Thank you, Your
Don't
Honor.
get caught. Don't get caught.
So assume the clip that you said was the basis for changing your PowerPoint on May 13th after the trial started had been in existence for months. You just got that clip, you say, in April?
I believe so, yes.
What was tell me the circumstances by which you got the clip. Did you ask for it?
Thank you, Miss Heather.
I was told there was a new interview.
Okay. Who initiated the conversation about the new interview?
I don't know if it was Mr. Brannon.
It was someone associated with prosecution?
Yes, I wouldn't have known about it.
Exactly. So somebody affirmatively communicated with you when about this clip?
I need to look, but I remember it being about mid-April,
Mid-April.
if I'm thinking of the correct clip.
What were you asked to do, if anything, with regard to that clip?
When I got the clip, I wasn't asked to do anything.
What did you do with the clip once you got it?
So they then indicated there was this suggestion of an alternative route. So then I looked at the alternative route description.
Wait, hold the hell up. Who just gave you an alternative route?
And added the alternative route.
He's gonna get himself
So
in
it was
trouble.
suggested to you by the prosecution that you look at the clip and they pointed out that there was an alternative route they wanted you to look at?
So I took it to be, we have additional evidence. Please look at the additional evidence and add it to your analysis.
Yep, that's the word, they. Who is the they, sir? I know, there's many mic drop moments so far, and we're just getting started.
On the topic of
Yes.
additional
To make it abundantly clear, he's also looked at every police report and every witness interview.
analysis by Aperture while this trial is going on, are you aware of Mr. Burgess submitting a report dated May 8th of 2025 in this case?
Yes, I received that report on May 8th.
Right, and so you were aware of the creation of that report on May 8th because you got a copy of it, right?
Correct.
Were you aware that Mr. Burgess was intending to submit that May 8th report to?
Showers, my understanding is he did it off of an interview that Karen had done.
The Commonwealth?
Yes, we had a discussion before that he had found new information that changed the timing.
Oh, he had found new information.
I hope not,
What is
Peggy.
your basis for saying he found new information as opposed to the information always existed, it's just it was pointed out to him that that should be looked at? What's the basis of your understanding that he found new information?
Objection to the question.
I'm going to allow the question, but you have to ask it differently.
I will, Your Honor. Thank you. What is the basis for the statement you made that Mr. Burgess found new information?
I guess it was his meeting and our discussions. He indicated that he had found new information.
Did you ask him, what do you mean by new?
No, I took it at what it said.
So,
Yes,
do you, as you sit here today, have any basis to say that that information is new as opposed to it's always been in existence?
Yes,
What is that?
what he told me.
Oh, so you relied upon the representation
Yes,
of
he did,
Mr.
Crystal.
Burgess. You didn't have any independent document to determine whether in fact it was new.
I don't quite frankly care whether it's new or not. I just care what's in the data. Whether it's new, old, I don't care. It's not relevant to what I'm doing. I don't say this is new data, this is old data. I just care what the data is.
Sir, you're the one that said you changed it because of new data. What the hell?
Sir, has Aperture ever submitted a report, a changed report in the middle of a trial to your knowledge?
I have no idea.
Do you know whether Aperture has ever submitted an amended report in the middle of a trial? You said you testified in federal and state courts. Can you recall one instance where Aperture has submitted an amended report in the middle of a trial?
So Aperture is like 290 people. I can only speak for myself. I have certainly done amended analysis. Only certain courts and certain legal systems require reports. But for example, rebuttal, analyzing testimony that comes up in court, getting trial transcripts. I very frequently have come up with new analysis during the trial.
Sir, my question is, as you sit here now, can you state one court case where you or Aperture has submitted an amended report in the middle of a trial?
I cannot speak for Aperture. I can only speak for myself.
Can you answer, speak for yourself, so can you then for yourself recall any instance where you submitted an amended report in the middle of a trial?
Amended reports? No. Amended analysis? Yes.
Thank you.
Thank you, Parker.
You're welcome.
Mr. Alessi, is this a good time for a break or 5 more minutes?
It's a good time, Your Honor.
Okay. All right, folks, why don't we just have one recess again? Dr. Wilkie,
Great.
Rest of the jury.
Love to hear the rest of it.
I know, you guys. I know. He even has to add the commentary of, I'd like to use the restroom. Okay, is this meeting your guys' expectations of how this was going to go once Alessi got up there? What is that? Oh, okay, that's their news. Okay, if you guys need to get a drink or go to the bathroom, let's do that now. I'm going to do that too, and then we'll fast forward and we'll get right back into it. I could not believe this guy. Thinks he's smarter than everybody in the room. He will be shown. What are you doing, Abby? Babe, you gotta get up. We ready? Oi. move this closer. There we go. Are they? I still have my sandwich here. I had to stop eating because I got too excited. So I'm like, I'll finish that later. Yeah. All right, let's go on ahead. Baby, you didn't smell my new perfume.
Okay.
Aren't you gonna come smell it? It's on my wrist.
Not too heavy.
You're
You know me,
supposed-
I like the fruity
You're.
kind.
This is fruit. This is the Rihanna perfume. This is the perfume that Rihanna wore when everyone says she smells so good.
Okay, smells good. Didn't deny that.
Okay. Why is this break taking so damn long? Let me find the right spot. Okay, here we go. Here we go. Thank you for the follow.
Dr.
You said it was
Welcher
nice.
was just using, at least my observation, his computer.
I
He still
love it.
has monitors on his desk. Could we have all that removed, Your Honor?
And by the way, it just came today. That's why I'm like, come smell my perfume. I'm super excited about
Just
it.
heavily sighed in there
Who?
in the courtroom. Somebody just.
Bev. That's Bev. Bev's always heavily sighing.
It was closed,
Closed, yes.
Would he open?
so it's just, did you just turn it off?
No, but I will. I closed it.
Dude keeps trying to use his computer.
You like want the computer all the way off or just everything?
Is he going to need to turn his computer back on?
I do not see a need for the computer to be turned on. Do we have the ability to put the presentation and documents from our
So I'm
sub?
gonna see counsel inside back,
Sure.
please.
Sidebar instantly. Dude kept opening his laptop again. Okay, who thinks that the reason he keeps going to his laptop is because he's looking for messages?
He's looking to find
Exactly,
out-
Samantha P says something is on that laptop, and I agree. I would love to have the defense look at that laptop. Honestly, it's probably Alessi.
He's probably trying to find
Thank you,
his
Ricky.
notes what he's supposed to say, in my opinion.
Well, he has a big stack of binders and notes and stuff, and then he has a laptop. I've never seen anyone testify with a laptop. Never.
The only time they're supposed to do that is if they have. Well, no, they're supposed to put it on a USB.
Yes, but this guy has his laptop,
That's a cyber.
and he won't
Lunch break,
stop
I'll
it.
remove those monitors, okay?
I'm sorry?
During the lunch break, I know it takes you a while to set up in the
Yeah.
morning. I'm gonna ask you to take all that down during the lunch break, okay? Thank you.
May I, Your Honor?
Yes.
Thank you. Dr. Welcher, we left talking about the amendments you made to your PowerPoint presentation. And in terms of the amendments, are you aware that the Defense Counsel received your amended PowerPoint presentation at 3 p.m. on Memorial Day? Are you aware of that?
No.
Probably.
And you began testifying the day after yesterday, correct, sir? Day after Memorial Day?
I testified yesterday.
Yes.
That's the day after Memorial Day, sir. Get it together.
Are you aware of any
Yeah, over the weekend.
activity in this trial of any kind before you testified yesterday?
Again, as I mentioned, I've been getting random emails, and then I've been seeing it pop up on my news feeds as well. But once I was aware of the reclusion, I made sure to not review any of that. But as recently as last night, I got an email that said biomechanical engineering job, or like applying for a job. And I opened it up, and it was some internet troll.
Sure.
This is Mountain Dew with ice. Other times it's water with lemon and ice, but there is
Or
lemon in
Sprite.
it. Or Sprite, yeah. I bounce between the two, but lately I'm addicted to my Mountain Dew.
I'm asking about emails from the prosecution.
Oh, no, there's been no emails about what's been going. I mean, there's been scheduling, when am I going to come, things like that.
How then was it determined that you were going to be able to amend your power presentation if you weren't communicating with the prosecution?
Go ahead.
I mean, they asked me about the witness statement of 138 right around May 13th.
How did they ask you about that, sir?
I don't recall if it was a Zoom meeting, a
Well, I
phone
love
call.
you, Parker.
So there was a communication with the prosecution. Might have been by Zoom, might have been by another method, but there were communications while this trial is going on relative to you amending your PowerPoint that ended up with an amended PowerPoint on May 13th. Do I have that correct?
I believe so.
Leslie, or no, Brennan.
Going to
Got it
switch
wrong.
topics.
Okay.
One of the goals of Aperture's analysis and reconstruction was to determine the location and timing of certain text stream events, correct?
Correct.
EDR data.
I'm sorry, my role.
Your role, yes. EDR, and just for clarification, EDR is Event Data Recorder, correct?
Correct.
I'm not
So
sure.
I'm going to
Randy.
refer to that, as you have before, as EDR, Event Data Recorder.
How long were you gone?
Good.
EDR data does not show the location associated with a text stream event, correct?
In this particular vehicle, it does not.
And the EDR data for this particular vehicle, namely the Lexus SUV, also does not provide the time associated with a text stream event, correct?
Not at the time of this event.
So the answer is no, correct?
That is not correct.
So let me ask the question slightly different way. The EDR data does not provide the time. The EDR data for the Lexus SUV that you've been talking about does not provide the time associated with a text stream event, correct?
That is correct.
Instead, every text stream event is associated with a particular key cycle on the vehicle,
Morning,
right?
Graham.
Correct.
There can be multiple text stream events in a single key cycle, right?
Correct.
And every time you start the car, this one you push the button, that's a new key cycle, right?
That will cause a key cycle.
In case anybody misses, what we heard so far is that in total, Aperture is getting paid $400,000 by the Commonwealth.
And the EDR data indicates the number of seconds into the key cycle that the particular event occurred, correct?
The EDR data, no.
So EDR data gives you no information about the number of seconds into the key cycle that a particular event occurred.
You're confusing EDR data and text stream.
I'm not, sir, I'm just
Are you
asking you a question.
So
If it's yes or no, I'm fine with that.
EDR data will, depending on the vehicle, sometimes it has information about GPS date and time. Sometimes it has ignition cycles, which are a little bit different than key cycles, which is why you frequently have different ignition cycles versus key cycles in EDRs compared to text stream.
So,
And on top of that, when the case is over, they sell the vehicles. If they don't get what they paid for, Commonwealth reimburses them.
let me ask it a different way.
Okay.
Aperture is getting paid over $400,000.
The text stream data indicates the number of seconds into the key cycle that a particular event occurs.
Yes.
Is that correct?
That is correct.
Very.
In order to properly determine the location and the timing of a
does.
text stream event, it's important that you correctly identify the trip that is associated with a particular key cycle, correct?
I think I'm going to say yes. The text stream tells you the trip.
Teresa.
I'm just asking if it's important that you correctly identify the trip associated with a particular key cycle. And do so by determining, in order to properly determine the location and timing of a text stream event.
So the text stream tells you the trigger event and it tells you the key cycle. So I'm not determining that, I'm reading that from the text stream data.
Okay, so in order to properly read, to use your verb, the location and timing of a text stream event, it's important that you correctly identify the trip that is associated with a particular key cycle. Is that a fair statement?
I think that's a fair statement.
If you associate the wrong
I swear to God, this guy's allergic to the word yes and allergic to the word no because he can't just say it alone.
trip with the wrong key cycle, then your estimate of when the text stream event occurred will be wrong, correct?
It can. I mean, you need to take the totality of the evidence in the text stream
She cut him off for their first break.
with the mileage, the overall timing into account.
So are you saying, sir, that if you have the wrong trip with the wrong key cycle, you can get the correct text stream event?
No, not necessarily. Again, you have to take the totality of the data.
My question is with regard to if you have the wrong trip with the wrong key cycle, then your estimate of when the text stream event occurred will also be wrong. Isn't that just a matter of logic, sir?
So, again, the text stream event tells you the trip and it tells you the time. If you're saying I'm, say, associating that with the wrong infotainment information or vice versa, then that would be wrong. But the text stream data tells you how much time is associated with each trip. There's no difference there.
I figured it out. We're in hell and he's our torturer. That's what this is. We're all in hell and he's our torturer.
Hey, look, we found the.
If you associate the wrong trip with the wrong key cycle, then your estimate of where the text stream event occurred will be wrong. Is that correct?
You can't associate the wrong event with the wrong key cycle because it keys in the key cycle with the event.
How are you saying, buddy? I don't understand.
Let me try it a different way.
Yeah. Good luck with that, Alessi.
Your analysis or anyone's analysis in conclusions regarding the timing and the location of the text stream data are only as good as your ability to correctly associate a key cycle with a particular event. Is that an accurate statement?
Yes or no?
Again, you need to take the totality of the data. So that is one element. You need to look, for example, at the mileage. You need to look at the timing of the events. So this is considered a tool in the analysis process. You need to look at the totality of data to see how it matches up with the physical evidence.
So are you saying that you can have an incorrect key cycle with a particular trip, but you can still get accurate timing and location of text stream data?
So again, you don't get incorrect key cycle with the trip. The trip and the key cycle are coded in by the text stream. If you are attributing an event to the wrong trip, which has a fixed key cycle, that could be a problem.
For the love of God.
Exactly. So if we could go, if Your Honor, if we could publish a slide, please, that is in evidence.
Okay.
Thank you.
What are we looking at?
Pardon me?
Which slide number?
I've got slide 9.
If you ask this guy yes or no, is the sky blue? He would say, no, it's not, because there's clouds in it, which are white.
So I'm going to use the acronym
No, we're not.
VCH that you've used
They
on
are,
your,
but-
do you recall using the acronym VCH on your direct testimony?
Yes, sir.
And VCH stands for Vehicle Control History, correct?
Correct.
You viewed the vehicle control history on September 23rd of 2024, correct?
In addition to the PCS data.
You viewed the vehicle control history on September 23rd, 2024. Yes?
That is yes.
You took photographs of the vehicle control history, including key cycle 1167.
Correct.
And in this screenshot, we can see 4 text stream events
Actually,
that are...
can you zoom in on the key cycle?
Oh, sure.
Now he needs don't work zoomed
Because I think when I got to, no, scroll. So when I got to it, you can see it was that key cycle 1264. The blue highlight was the last file that was written on key cycle 1167.
Right.
So to answer your question, I got it at 1264.
So if we can go back so we can see the 4 text stream events, I just want to reestablish the foundation here. In this screenshot, we can see 4 text stream events that are associated with key cycle 1167, correct?
Correct.
But isn't it true, Dr. Welcher, that there were actually 10 text stream events associated with just that one key cycle 1167?
Correct. I gave you the original files.
Right. So you are aware that the Commonwealth had maintained up into your firm's engagement that...
Are you saying there's no basis for the question?
You're saying?
All right, I'm going to allow the question and hear it.
You are aware that the Commonwealth has maintained up until your engagement in September of 2024 that all text stream events associated with key cycles 1164, 1165, and 1167 occurred while the Lexus was in the custody of the Massachusetts State Police at the Canton Police Department.
Thank you for the follow,
So the
guys.
objection
Thank
sustained. You need a
Rebecca.
foundation, Mr. Lessie.
Sir, as part of your work and your review
Thank you,
of
Lucy.
the many documents that you referenced on your direct examination, did you review the text stream events associated with a Lexus SUV?
I reviewed the one I downloaded.
Pardon me?
I reviewed the one I downloaded.
Right, and did that, what you download, include key cycles 1164? Did it include that?
It did.
Did it include 1165?
It did.
And did it include 1167?
It did. It did not include 1166.
I didn't mention 1166, sir. I only mentioned 1164, 1165, and 1167. I purposefully skipped because I didn't understand you had reviewed it. So here's my question. You therefore, based upon the fact that you reviewed them, and you said it's important to understand timing, etc. That's very important in your forensic analysis, correct?
Yes, sir.
So let's go to the timing question and you understand where the Lexus has been at various points in time. You testified to that in direct, whether it was at the Canton Police Department, whether it was being towed, correct?
In addition to having Mr. Burgess' analysis of the data.
In addition to Mr. Burgess' analysis, so in that analysis contained locations of where the Lexus had been.
It contained where it had been and also include date and time, when it was turned on, when it was turned off.
Exactly. So not only did you have all the locations, you had dates and times associated with the location where the SUV, the Lexus SUV, had been, correct?
Correct.
Now to the question. Based upon that review, that knowledge, that understanding, those bases, you're aware, and you've reviewed, by the way, Trooper Paul's reports, correct?
I have.
There were 2 reports of Trooper Paul. There was his original CARS report and then a supplemental report that were listed in the documents you reviewed. Do you recall that?
I don't recall that, but I'll take your word for it.
I don't want you to have to take my word. Do you recall, sir,
No, I
that there
don't.
were do you recall that there was a report of Trooper Paul?
Yes,
Okay, and you read that report, I assume, sir?
I did.
And it would be important for you to read that report and read it carefully because it addressed the subject matter that you were addressing, correct?
No, I did my own independent analysis. As a matter of fact, it'd probably be more important that I don't do that to avoid confirmational bias.
But you did read Trooper Paul's report,
Of
correct?
course.
So, you therefore are aware that the Commonwealth has maintained up into your engagement.
Yeah, I'm gonna see a sidebar on this.
She doesn't want him to answer those questions because it makes the prosecution look terrible,
Yep.
in my opinion. Sorry. Gotta put that in. Alright, love you.
No, you two drive safe.
I will. I'll let you know when I get there. I'll probably
Okay.
listen in on my way.
Okay. Don't worry, guys. We practice patience with parameters, so let's just zip right ahead. Oh, God, please don't let me get... Okay, here we go. Here we go. We practice patience with parameters. We don't like sidebars.
May I, Your Honor?
Yes.
Thank you. Are you aware that over the course of the Commonwealth's and your investigation into this case, that the theorized time of the alleged contact of the SUV?
So there's two words, just strike theorized.
Okay. Thank you, Your Honor. Are you aware that over the course of the Commonwealth's investigation and your...
Hold on, Mr. Leslie, the court reporter can't hear.
Thank you. I will.
Thank you.
I'll object again to the question that's coming.
No, not yet.
Can I
Go
begin
ahead
my
and
question?
ask an appropriate question, Mr.
Sure.
That gives me Carly Russell flashbacks.
Do you have knowledge whether there is one time or more than one time
I think we're on 5.
for the Commonwealth's position, as you know it from reading documents that you said you've reviewed, that there are different times alleged for the incident to have occurred at 34 Fairview?
Objection.
Sustained. You can ask the question, remove part of it.
I'm sorry, Your Honor?
You have to remove part of that.
Okay, understood, Your Honor. Do you know whether there is more than one time that has been proposed by the Commonwealth for the impact alleged to have occurred at 34 Fairview?
Objection.
Sustained.
I'm going to ask for an instruction.
I'm not giving the instruction now.
Dr. Welcher,
But first you don't
in terms of
put yourself off
the
the
analyses
timer.
that you have reviewed in this case, is there one time that you understand there to be
They're only showing what you see on the screen right now.
for a hypothesis for the time of the impact at 34 Fairview?
Objection.
I'm going to see you again, folks. I'm sorry.
Yes, we are on another sidebar. Don't worry, we practice patience with parameters.
May I,
Yes.
thank you. Are you aware that over the course of the Commonwealth's and your investigation into this case,
Did I go too far back?
that the theorized time of the alleged contact of the SUV,
So,
Yeah, I went too far. Hold on.
whether there is more than
Oh yeah, this case is a hot mess. It really is.
excuse me.
Guys, if you could do me a favor and put IMO, which means in my opinion, next to what you say, if it's something that comes off as if it's being said fact, greatly appreciate it. And tapping on this side of the screen is also a big thing that I greatly appreciate. Thank you.
Yeah, you're right.
yes.
Thank you.
Yes, and please share out
I'm
the
going to move
live.
to, for the moment, we'll come back to the other topic a little bit later. As we discussed earlier, you've got on various documents, you're a biomechanical engineer, but I've also heard you make reference to biomedical. Can you just tell me what you consider yourself, sir? Is
Sure.
is biomechanical engineer something you consider yourself to be?
Sure. My degrees are in biomedical engineering. The discipline within biomedical engineering that I practice is biomechanics.
Right. And so is it accurate to say that you are a biomechanical engineer?
Yes.
And you say that much in your report, correct?
And CV and resume I gave you.
Right. Now, in your report, and Your Honor, I have no issue if he refers to the
Thank
page of his report.
Do you have a paper copy or do you need your?
I do.
If you, sir, could turn to page 9 of your report.
Okay.
And on page 9, you state, as a biomechanical engineer, I have no opinion on any aspect of, and I think you're referring to Mr. O'Keefe's medical treatment or medical diagnoses. I have conducted an accident reconstruction and biomechanical engineering analysis of this matter. Did I read that correctly?
Did?
In that statement, I assume, given you wrote it, is a fair representation of your professional role in this case?
Yes.
And you go on to add on page 9, my
Abby,
biomechanical engineering analysis
That girl.
is determining the effects of physical forces on the human anatomy. Did I read that correct?
You did?
And on your direct examination, is it correct that you stated as a civil engineer, you made an analogy, you assessed the cables and beams of a bridge as you would assess the cables and beams of a bridge, you assessed the human anatomy, you made that analogy, correct?
The analogy that bones are my bridge elements, cables are muscles and ligaments.
Right. And you stated that it's the job of a biomechanical engineer to quantify the force acting upon a person to determine the cause of their injuries, correct?
That is part of what we do.
It's part of, but it is therefore something that a biomechanical engineer does, correct?
Given sufficient data, yes.
So, you know do you know what a force calculation is, sir, when I refer to that term?
I believe so.
Yeah, I believe I did hear it's gonna rain.
So,
What do you believe it to be?
well, force is usually a physical measurement, But you can also use Newton's second law, which is force equals mass times acceleration.
That's exactly what I wanted to get to. Newton's second law.
Okay.
The clock on the screen right now reads 12:33 for the part we're at. That's the only thing I know how to tell you where we're at.
Is, and sometimes referred to as the second law of motion. And in the second law is force equals mass times acceleration, correct?
Correct.
No spoilers.
And just sort of
You're
like
welcome.
simple algebra, sometimes you have one or more of those, but I'm focusing on when you're
Yeah.
trying to determine, so you're pulling something out.
Calculator. I thought you were going to ask me numbers, do calculations.
All right, we need to do, if we're gonna do that, we need to do it with the court's permission.
Sorry.
If you feel you need to do that, just let me
You
know.
can just leave it right
All
here.
right.
So I just want to get the principles down first. So Newton's second law, force equals mass times acceleration, and force is oftentimes what you're trying to calculate in a force calculation, correct?
Calculate or measure, yes.
Yes. And Newton's first law is the law of
Physics.
generally inertia. An object at rest tends to stay at rest. Object in motion tends to stay in motion. We're not talking about that in force. We're talking about Newton's just second law, correct?
You asked me two questions. Newton's first law is generally, as you said, it could be at rest or at constant velocity, but yes.
Okay. And that Newton's second law is generally just a mathematical calculation, correct?
Yes.
So what I'd like to do is to turn to page 11 of your report. And on page 11, you discuss the force calculation in conjunction with the part of your report where you discuss your experiment where you dropped a test dummy backwards, correct?
Correct.
You determined that a fall of 69 inches, at that fall, Mr. O'Keefe's head would have accelerated with 458 G's of force.
That's what we actually measured
Right,
in
and,
the test.
and can you tell the jury what is meant by G's?
So G's is a measure of acceleration. If you use the acceleration as measured in feet per second squared,
That's not what Snoop Dogg said G's are.
if you divide it by 1G, which is 32.174 feet per second squared, that gives it to you in G's. People often heard about fighter pilots losing consciousness at 6 or 7 G's. Basically because your blood's getting sucked away from your head, not because you're being impacted. But G-forces, or G's as they're more properly called, is a measure of the acceleration. It's just whatever the acceleration is divided by what we all feel when we're standing here, which is 1G of gravity.
And you estimated Mr. O'Keefe's head weight of approximately 15.7 pounds. You used a percentage. Is 15.7 about right for the mass of
Yes.
the head? So if we apply Newton's second law, we keep F, force open, as the unknown. We take and apply the mass, which is 15.7, multiply it by the acceleration. You end up with a force acting upon Mr. O'Keefe's head of 7,200 pounds. Do I have that right? That's right out of your report.
So that math is all correct. Falling backwards onto a hard surface from his standing height will give you approximately 7,200 pounds of force.
And that 7,200 pounds is the previous unknown F in the Newton's second law equation, correct?
Correct.
So now we have an answer for F, 7,200 pounds. Now you then go on to note that the applicable scientific literature states that a fracture to the occipital bone, and just to review, the occipital bone is the back of the head right here, right?
Correct.
So you then, as I understand it, you go to the scientific literature and you concluded that a fracture to the occipital bone can occur with an average force of 1,634 pounds from a fall distance of 40 inches, correct? I'm sorry.
How many inches?
40. That's in your report?
Well, you mixed two things together. There was stuff that reported force data, you had those numbers correct. A range of between 1,150 and 2,150, a mean of 1,634 pounds. And then it says, and a drop distance as low as 40 inches.
Right. And is the number 634 pounds a proper number for an average force?
Did you say 1,634 pounds?
1,634.
Yes.
Okay. So what I want to do is see if this is correct. So if you can get a fracture of the occipital bone in an average force of 634 pounds.
No. 1,634.
Sir, please do not interrupt our second husband while he's talking.
I thought that's what I said. If I did, I missed.
Oh, I'm sorry. I just heard 634.
No, 1,634.
My apologies.
And you compare that to the 7,200 pounds of force that you calculated. Surely you're going to have a fracture of the occipital bones through that calculation in that comparison, correct?
Correct. Falling on a hard surface can definitely fracture your skull.
So I'm not getting at the manner. I'm just applying the Newton's second law. Newton's second law doesn't look at manner, does it? It just looks at force equals mass times acceleration. Newton's second law doesn't look at the surface, does it?
This is one of those moments where you want to get away. You know what I'm talking about, right? He thought he was the smartest guy in the room. Nope. So that want to get away should be said right here.
So it's a function of the surface. The A value is a function of the surface you hit.
So you're saying acceleration depends upon the surface?
Yes, of course.
Okay, all right.
For an impact, it does.
Now, let's go to the study you cited. Injuries to pedestrians in real accidents in their relation to collision and car characteristics. That's in your report, correct?
What reference number?
Please would be nice,
May I,
sir.
Your Honor, grab the report?
Yes.
Thank you. If you can, it's in your report, sir. If you can find it, I'll do it in parallel with you.
One thing I can't understand, didn't you guys say he was like 67 years old or 70, Alessi? He looks better than most 30-year-olds. I don't understand it. Oh, I know, Michelle. He's totally arrogant. 67. Yeah, that does not make sense to me. Mr. Second husband, when you get this, we want to know your secret, please, sir.
Number 25.
That's the one I think it is. I just want to check your report.
Would you like me to actually pull up the paper?
No,
Okay.
just want to get to the. That's it. Number 25. We're talking about the same one. Now, isn't it true that this study states that head injuries are the most common injury type for motor vehicle collisions, constituting more than 61% of all injuries sustained from motor vehicle collisions?
Or could the witness see the document that's being referred
Do
to?
you have your report in front of you?
I have my
You forget, though, it's upside down pineapple juice.
report, but reference 25 is not in the section he's referring to.
No,
Why don't
send
you
me
show it
that.
to
I
us,
want to see
Jess?
I
that.
do not have with me a copy of the report he cites in his reference. He did, can I ask another question? Your Honor?
Yes.
Thank you. Dr. Welcher, on your direct testimony, did you not discuss the percentage of
Me
pedestrian
too, Me too.
injuries and relate it to heads? Did you not, on your direct, talk about percentages of injuries that are head injuries in impacts of pedestrians with cars?
Yes, I did.
Okay, so you came up with a number. What I'm trying to do is to,
You're not tattling on me. I put on the screen right there. This is the delayed live. I'm not trying to pass it off as if this is actually live. We are delayed. We practice patience with parameters.
compare that number to the number in the study that you cite. If you don't remember, that's okay. We'll just move to the next
Can I
question.
go to my slide?
Whatever you can use to determine what was the percentage that's in the study that you cite in footnote 25 of your report?
Sure, that was also from my presentation that I gave. It's 61.5 for all injuries, 12.7 for fatal injuries.
Thank you. So I'll repeat my question and then we'll get it in logic. So that study states that head injuries are the most common injury type from motor vehicle collisions, constituting slightly more than 61% of all injuries sustained from motor vehicle collisions, correct?
That number is correct. You're quoting a sentence. I would want to pull the paper up, but the number is correct.
Okay, so doesn't this article also state that of all head injuries sustained by motor vehicle collisions, only 12.7 of them are fatal?
That does, yes.
Did you mention that only 12.7 are fatal on your direct examination?
It's circled with a red box on my slide.
Did you mention that on your testimony on
I
direct?
thought I did.
No, you
This
did not.
article was published back in 1979, correct?
I believe that's correct.
It's 46 years old, therefore, if I did the math correct, right?
That sounds correct.
Are you aware that given advancements in science since 1979, advancements in medicine, advancements in technology, the currently understood most common injuries as a result of pedestrian motor vehicle collisions are injuries to the lower extremities?
I'd have to see the study. It wouldn't surprise me. Car technology, especially, for example, with pedestrian safety systems, has caused autonomous braking. So you're getting fewer higher severity crashes, which results in a higher propensity for lower extremity injuries. It's the higher extremity crash that causes the head to either slap into the hood or the window and or bounce off, to where if you get the lower severity crashes, you can still maintain a standing posture. So it wouldn't surprise me if that's accurate.
So you would agree that as of January 2022, the most common injury as a result of a pedestrian motor vehicle collision is one to lower extremities?
No, I wouldn't necessarily agree with that date. And again, you have to look at frontals versus rears.
So you can test
Jill.
that the most commonly understood injury as a result of a pedestrian motor vehicle collision is injuries to lower extremities.
Maybe that's a bonus once.
So I'll allow the question.
So I'd want to see the data. Again, most cars, for example, this Lexus has a pre-collision system in it that will start to apply the brakes if it senses a pedestrian at the front of the car. And so
One of the biggest bombshells of today was that they're paying Aperture over $400,000.
So for frontal collisions, it's transitioning, taking what were head injuries, because they're more severe, higher speed crashes, making them lower speed crashes and shifting the injuries to the lower extremities. Just like airbags shifted the head injuries away from the severe ones, and we started getting more or higher ankle and lower leg injuries. So the change in the technology, but for backing, that may not be the case because you have different geometry on the vehicles and you have different safety systems.
I'll try it a different way.
Mm-hmm.
Do you have knowledge, as you sit here today, whether the most common injury from a motor vehicle accident is to the lower extremities?
I'd have to look at the literature. I have the article I gave you.
So the answer is you don't know the answer to that question. Is that correct, sir?
I don't know it off the top of my head.
All right. Newton's second.
The SUV purchase, they actually bought two. They bought one that was just like John's and one that was just like Karen's. And what they do is after the trial's over, they will sell them. And if they don't get the amount that they paid for when they bought them, the CW gives them whatever they lost out on.
Law analysis that we went through. Force equals mass times acceleration where we came up with the 7,200 number.
Thank you for the follow.
You didn't discuss
Drink that water, sir.
calculation on your direct examination, did you?
I don't think so. We didn't discuss a whole bunch of those things that were that wasn't necessarily an opinion, that was a sub-opinion or basis for my opinion.
You didn't discuss that Newton law calculation on your direct examination, did you, sir?
So in a way I did, because I said my drop testing shows that you can do this. So I didn't quote that number, but we are going through the specific numbers now. But I absolutely did say, as a matter of fact, I showed a video of my drop testing and talked about how falling onto a rigid surface, a hard surface, can cause a skull fracture.
Did you discuss on your direct examination applying 15.7 of the head weight to 458 Gs and come up with a number of 7,200? Did you do that on your direct examination?
Those specific numbers, no.
Thank
the general
you.
concept of the drop testing and what it showed, yes.
So instead of
Court TV just released a headline. Expert admits to changing. Oh, damn. It went away too fast. Admits to changing. What was the word they used? Presentation, report midway through the trial. I'm glad that you admit that, Court TV.
of that calculation, you referred to a flow chart comparing injury characteristics of flaws versus blows. Do you recall doing that on your direct?
So you asked me two questions. You said instead of, so that's no, it's not instead of. They're two completely different topics. So no, I didn't do that instead of.
Okay.
I looked at a force analysis, then I looked at 3 peer-reviewed publications that were attempting to differentiate whether an injury is associated with a fall or a blow, an assault, and they came up with a metric for doing that. Those things are completely separate.
Let's ask it this way. Did you, on your slide presentation that you presented to this jury, did you put the inputs into F equals M times A in your slide presentation with the numbers we talked about of 15.7 for the M and 458 for the G to come up with 7,200? Was that anywhere on your slide presentation?
So the slide presentation showed the 458 Gs. The rest of it was not on there.
Thank you.
You're welcome.
This man is driving me crazy.
You also indicated that the laceration above Mr. O'Keefe's right eye is consistent with the shape and height of the fin on the top of the Lexus SUV. Do you recall that?
Correct. It's actually properly called a spoiler.
And so you would call it a
Diane, who are you speaking about? You can't possibly be speaking about this case.
spoiler instead of a fin?
Correct.
Fair enough. We'll call it a spoiler. You visited the scene at 34 Fairview, correct?
I did.
You stated that you like to visit the scene while you're working as an accident reconstructionist so you can get a better understanding of the data?
I'd use the word like, but we want to go to the scene to see the scene.
When you visited 34 Fairview, did you go into the garage at 34 Fairview?
No, I actually didn't set foot on the property.
You didn't set foot on the property?
No, I stayed in the street. It's my understanding there were new owners.
How can you recreate the environment if you never stepped on the friggin' property?
Did you consider the scene limited to the road?
So the access I had was to the road. The laser scanners and the photographs will extend further, but I didn't have access to the interior of the house.
Oh, so you didn't access the entire scene, correct?
Nope.
In my opinion, I did access the entire scene. I didn't physically step 7 feet onto the grass to the point of rest, but I stood and photographed where that was. I didn't want to trespass.
Where did you understand the body of Mr. O'Keefe was located?
I know it was 7 feet in from the grass. I've seen cruiser cameras showing people around a body. It's slightly north and slightly south and a little bit west of the flagpole.
But you didn't access that part of the scene that you just described, correct?
I absolutely did. I took photographs of it. I didn't trespass and stand at that exact location, but I stood right there. We scanned the whole thing. The scanner uses a laser beam that goes out, 150, 200, 300 feet. So we scanned all that stuff.
Did your scan topography?
Yes.
Then you know that there is a berm raised above street level, correct? If you did the scan.
Want to get away?
Correct.
Do you know the height of that berm?
I believe it's 4 inches.
Nowhere in your report, when you're comparing the height of Mr. O'Keefe to the spoiler, do you account for that 4 inches of the berm, do you?
So yes and no. As I indicated, we don't know exactly where the...
Guys, I'm going to ask you for a favor. When people come in and they sit there and say, she's guilty, please just ignore them. We're getting a lot of trolls lately. I'd prefer if we just ignored them entirely so they can go away. I'm kicking them out immediately.
point of impact is, whether he was completely in the road or up on the berm.
Thank you.
But for example, where the tire spins on the Lexus, that could be where she's driving up on the curb. And so then that tire will be at the height of the curb. So if he's standing on the higher part and the right rear tire of the Lexus goes up there and spins, then that would be at the same height. We don't know the exact point of impact. So I don't know whether he was on the road or in the street. Excuse me, on the street or on the side of the road.
Exactly, but when you did your depiction on your slide, when you remember you had the ruler and you measured the height.
Absolutely. Yep.
Where was it? It was you. Was it you in that slide?
It was.
Where were your feet?
On the ground.
Not on the berm, correct?
Correct.
Okay. So you chose a measurement which was the ground to the top toward the spoiler, and you took a measurement. And you said that approximates the height of Mr. O'Keefe, correct?
Of the laceration of Mr. O'Keefe.
Exactly, because what you were doing was you were trying to determine and present testimony on whether or not that laceration could be caused by the spoiler, and to do so you had to take measurements, correct?
Correct.
So,
side note, Sandra just sent me this. Cassie has welcomed her third baby.
you chose to place Mr. O'Keefe in your simulation on the ground. You didn't choose to put him on a berm that would be 4 inches higher, did you?
Nor did I put the Lexus 4 inches higher. I didn't do either one of those.
So the point is, it's certainly possible that if there's 4 to 5 more inches, that would take that eye out of the ability to be hit by the spoiler. Isn't that correct?
No, because if it's 4 to 5 inches higher and he leans his head down or reacts to it, again, we don't know the exact position of his head.
Did you, in your slide yesterday, describe the possibility that his head could be down? As I understand it, you're positioning that photo just like this. You're not positioned like that in any photo you presented to the jury, were you?
I'm trying to make it clear. We don't know his exact body position at the point of impact, nor do we know the exact position on the ground. So, which is...
Sir, it's up to the jury to decide if there was a point of impact, not for you to say it in a court of law.
Part of the reason why I haven't tried to exactly simulate this, because we don't have enough parameters to do that. So I don't have that information. I'm showing the geometry relative to someone of Mr. O'Keefe's height.
So you don't have the information to do that properly, so therefore you can't conclude that he had a laceration to the eye from the spoiler by your own answer that you just gave, correct?
So it was done properly. We don't have absolute information to say where exactly he was. I'm pointing out that the physical evidence, the height matches the height of the laceration. That is one data point of many data points.
So you would have to at least concede that the level of his eye could be non-contacting that fin or spoiler, because you don't have information as you just described. Is this right?
It could be from contacting the ground.
Pardon me?
It could be from contacting the ground. It could be from other things.
But you don't have the information necessary to conclude with any certainty that Mr. O'Keefe at the time of impact had a level of his head in an upright such that it hit that spoiler. You don't have that information, correct?
We don't have that level of certainty. We have that the height and geometry matches.
Keep in mind, he was found face down.
And you didn't take into consideration the berm, and you didn't mention the berm at all when you were discussing this measurement with the jury yesterday, correct?
That is not correct. You asked me two questions. I absolutely considered the berm. And the second question, when I presented it to the jury, I mentioned the berm when we showed the picture of the shoe in the snow, but that was it.
That's my question. I'll ask it a different way. When we were talking not about finding a shoe in the snow, and you mentioned a berm, I'm talking about when you did the measurement of whether or not the laceration could be caused by the spoiler. You didn't mention accounting for berm height when you discussed that measurement with the jury, did you?
That is correct.
Likewise, you didn't present any Newton's second law analysis regarding the front of Mr. O'Keefe's head with respect to whether his head was contacted by that spoiler, did you?
Correct. Again, it was a glancing hit. We wouldn't be able to do that.
Oh, so it's a glancing hit to the front of the head is your hypothesis?
This whole pedestrian impact is a glancing hit.
So you can have your arm to the side like this, with the back of the vehicle coming like this, and you could glance the right eye with the arm out. Is that what you're saying?
That's what my picture shows when I'm standing next to the car. I could probably find the slide for you.
So you didn't do a force analysis to determine how much force would be applied assuming a contact with the right eye, did you?
That's correct.
And force analysis is what biomechanists do, correct? That's what a biomechanist does?
That is part of what
they do.
So I lined up his anthropometry relative to the known height of the vehicle.
You attempted to line it up. That's one method, but another method is to apply Newton's second law like you did to the back of the head when he fell, correct?
Correct, if we had more information.
Mr. Leslie, why don't we break here?
Thank you, Your Honor.
So jurors, your lunch is here.
Don't worry, we practice patience with parameters. So we'll just zip on ahead.
Decided. He may not testify that Miss Reed's Lexus collided with Mr. O'Keefe because that conclusion is not based on the application of reliable scientific methodology.
In answer to the question we left off with yesterday, the judge barring crash reconstructionist Dr. Judson Welcher from testifying that Karen Reed's car hit John O'Keefe.
I just wanted to hear what they said. Hold on. I thought that was them back. So I wanted to hear what they're going to say. This is a really long 15-minute break. Really long. Man, that's a long 15 minutes. I can't see your guys' comments because I'm trying to find the place. good news and bad news. Well, not bad news. We're caught up now. We can't fast forward anymore. We are now officially caught up. That was a lot more than a 10-minute break. I'm not going to listen to the elevator music. Hi, Natasha. How are you? I cannot believe that we're actually, like, this is real. Like, what? Next week, we start covering Lori Daybell, too. So could you imagine having this trial on Lori Daybell? It's going to be insane. Okay. She lied. That was not a 10-minute break. I feel like we're out of control now. I don't like not having the control over fast forwarding. He's very good at what he does. Have you? Well, I'm glad that you came in. It's good to see you. This trial was expected to last 8 weeks. No, this is Lori's third case. I'm jealous. Take lots of pictures. I want to see. Something just posted, said the elastination. They called it the elastination. Yeah, I totally want to see. It was to Aperture, and it was over 300. It was actually about 400. How many locals do we have in here? Assuming we do have some. How do you guys feel knowing they paid $400,000 for this expert? Elastination, yes. We're going to have to steal that one. Locals in Missouri. I'd be furious. What behavior? I just got a warning. My behavior is not in line with policies. If you guys are not following me, follow now because I'm going to have to restart. I was just sitting here having a nice chat with my friends here. I know. But so I don't lose my count, I have to restart. So make sure you guys are following me on this side. Hello. All right, guys. I'll be right back. I'm just going to stop it and restart it. I'll give you guys all 5 minutes to get back in. See you in a minute.